It's my great honor today to introduce this year's keynote speaker for the E. Lawrence Barcella Memorial Address, the Honorable Bernice Donald of the United States Court of Appeals for the Sixth Circuit. Judge Donald received her law degree from the University of Memphis Cecil C. Humphreys School of Law and holds a master's in judicial studies from Duke University and an honorary doctor's in law from Suffolk University. Prior to being appointed to the U.S. Court of Appeals by President Barack Obama in 2011, she served on the U.S. District Court for more than 15 years. Judge Donald is currently a member of the American Law Institute and serves as chair of the ABA Center for Human Rights. Prior to this, she served as chair of the ABA Criminal Justice Section and secretary of the American Bar Association, along with serving in the ABA House of Delegates until August of 2018. Judge Donald has been a faculty member at the National Judicial College, the Federal Judicial Center, and the Judge Advocate General's Legal Center and School, and has also served as faculty for the Federal Magistrate Judges Conference and as a jurist in residence at American University, Washington University, and several other schools. In addition, she has served as faculty for international programs in more than 20 different countries. I have had the great pleasure of working with Judge Donald for many years now in the criminal justice section, and I can tell you that there is no one who brings more energy and excitement to the work that we do. As chair of the section, Judge Donald focused on many pressing criminal justice issues. One I want to mention in particular is her important work related to implicit bias. Bringing attention to this issue and its impact on criminal justice was a centerpiece of her year as chair, and she has continued to lead our efforts in this field as co-chair of the section's Implicit Bias Initiative. Under her leadership, the section has published one of the leading texts on implicit bias and the law, and has led trainings and conferences on this topic all over the country, and in fact, the world. Through this work, Judge Donald has become a thought leader in this field, and by association, she has made the criminal justice section a leader in this work as well. I want to thank Judge Donald for her incredible contributions to the criminal justice section of the ABA and to the larger criminal justice community. We are inspired, energized, and excited by your work, and we're honored for the opportunity to hear from you today. Please join me in welcoming Judge Bernice Donald.
Thank you so much, Lucian, thank you for that generous introduction. I had planned to simply acknowledge him as our inspired and visionary leader, but that introduction compels me to tell you a story. And I will tell you that this will not count against my time. There was a story in the Reader's Digest many years ago about a man who lived a life of excitement and rowdiness. He was the kind of guy who was sort of always at the bar, and not the legal bar, but he was there where they were consuming alcohol, and he would get into fights and he would challenge people. And one day he got into one and someone got the best of him, and he died. There was a funeral, and it's been said that there's always somebody, no matter the life you've lived, who will find something good to say about you on that one occasion. And on this occasion, the minister who was eulogizing him talked about what a kind family man he had been, how much he had contributed to the community, how much he loved his family and supported them, and on and on. And at that moment, the widow hunched her young son and said, "David, go up and look in that casket and see if that's your father, because I think they've got the wrong man." And in listening to Lucian's introduction, as I was sitting there, it was at times for me remarkable, and I was a little bit unsure that I was the person that was supposed to get up, but thank you so very much. I want to acknowledge the iconic Ray Benown, who is really the inspiration, the leader, the founder, the collaborator of this white-collar crime program. Were it not for him, we would not be here today. And Ray, we continue to thank you, not only for organizing and beginning it, but also continuing to support and work in this field. I want to thank all of my colleagues at the criminal justice section, and I want to especially thank my friend and criminal justice colleague, Sandy Weinberg, for inviting me here today to give these remarks. And now I will get into my official talk. When I thought about what I might say to you today, I went back over my own life and my journey to the law, and the constant that has been in my life has been service. And so I thought I would talk to you about that, because you are the best and the brightest. You enjoy the highest reputation for knowledge, skill, and ability in the legal profession. I want to lift up the name of Charles Hamilton Houston for you. Many of you may not know that name, but he was the architect of the Brown versus Board of Education strategy and one of the leaders in the civil rights movement. He was the dean of Howard University, and he was the person who taught many of the iconic lawyers in that area about how to go and attack the institution of segregation and Jim Crow. He is the person who sort of provided the strategy to Thurgood Marshall and others as they went around the country and challenged that institution. He said that a lawyer is either a social engineer or a parasite on society. And while his comments were directed primarily to those lawyers upon whom he placed the burden to go around the country and attack those institutions which were not espousing and emblematic of our laws, that edict, those commandments, are no less relevant today. There are issues that we need as lawyers to challenge today, and that's what I want to talk to you about. And I want to go back to 2003, when Associate Justice Anthony Kennedy came to the American Bar Association at its meeting in San Francisco, California, and he gave the lawyers there a call. He observed that the responsibility of the criminal justice system is the responsibility of every member of the criminal justice system, including civil practitioners, prosecutors, criminal defense attorneys, judges, police, and he said of every citizen. Justice Kennedy noted at that time that the inmate population in the United States was at some 2.1 million people. And we know that today it has spiraled even beyond those numbers, although some reports say that it is either leveling off or coming down with some of the initiatives that have taken place. But he remarked that 1 in 43 persons in the United States would be incarcerated, compared to 1 in 1,000 in places like England, Italy, France, and Germany. He affirmed that we in the United States incarcerate more people than any other place on the planet. He also noted that more than 40% of the prison population was African American, and those statistics are still true. According to Justice Kennedy, the federal sentencing guidelines played a really pivotal role in some of those statistics. And he noted that some of the principles that undergirded that system of guidelines really had an unintended consequence. He said, as Justice Breyer pointed out then, the compromise that led to the guidelines led also to an increase in prison terms. And he urged that that compromise be revisited. He said the federal sentencing guidelines should be revised downward. He made an important statement. He said, I can accept neither the necessity nor the wisdom of federal mandatory minimums. In too many cases, mandatory minimum sentences are unwise and unjust. Well, today, 15 years later, Justice Kennedy has retired from the court. A lot of things have changed, but a lot of things remain the same. And as he mentioned, we lawyers have a role in impacting policy, in helping to shape legislation, and in helping to really attack some of the things that provide those unjust conditions about which he spoke. Why do I say that? I say that because of my own life experience, and no, I have not been to jail or prison, but there are other things that I want to compare it to. We, as the United States of America, have always had good, strong laws. We've always had them. We had good, strong laws during the time of slavery. We had good, strong laws during the time of the Civil War. We had good, strong laws during the Second Reconstruction. We've always had them. But laws are not self-executing, and it takes more than strong laws. It takes people of goodwill to go forward and make certain that the laws that we have are just and equal and produce justice. The American Bar Association has it as slogan, defending liberty and pursuing justice. That pursuit requires a commitment, a sustained commitment of men and women of the profession and other related professions to make certain that we achieve that objective. I want to mention, as I said before, about my own life experience, and I want to just give you this real life example because many of us, as we sit here today, say that those things to which I advert are long past. We have moved well beyond that, and that was a long time ago, but I want to point out to you the recency of that. And I know Judge Carlton Reeves is in the audience today, and you'll hear from him later on, but I want to invite you to go back and read an opinion of Judge Reeves or ask him about it when he's up on the panel, where he really sort of brings some of that history to the fore. I grew up in Olive Branch, Mississippi. During the time of intense segregation, I was one of 4 African American students who desegregated the previous white school in Olive Branch. We know that the first of the Brown cases were filed in 1951, and at that time I was unborn. The Supreme Court issued Brown 1 in 1954 and Brown 2 in 1955. I began school in Mississippi in 1957, and please don't do math on me because I'm not attempting to tell you how old I am, but when I began school in 1957, and this is 3 years after Brown 1 and 2 years after Brown 2, I began school in a 2-room cinder block school where grades 1 and 2 were in room 1 and grade 3 was in room 2. That school had no cafeteria, no running water. It had no facilities for the students to really get the kind of quality education that they should have. The students who went to school who were grades 4 and above went to school at the black church, the 1-room black church across the cemetery. And those grades were organized around church pews. There would be 2 church pews that housed grade 4, 2 more that housed grade 5, and the teachers sought to teach students in that environment where they were all collected in this one room. Even though we had wonderful laws, in my community, African Americans were still in segregated shopping facilities and restaurants. In fact, it was not until my junior year in high school that I had the opportunity to actually go to a restaurant proper. But we had those good, strong laws. We just did not have people who were actually making sure that the laws were either properly applied or were totally inclusive. In the early 60s, when I was still a young person, 3 young lawyers came to Mississippi, came to Olive Branch to help people register to vote, and to help desegregate public facilities. They were 3 young white lawyers, no doubt young lawyers from the American Bar Association. 2 were from California, and one was from New York. And those young lawyers were brave young people. And as I think about it now, they were incredibly brave because they didn't know us, we didn't know them, and they had no obligation to come to the South to help a people with whom they had no real connection. 3 of them stayed in our home. Those are the 3 to which I refer. There were many others spanned out in the community. And as I looked at those young people and I saw how brave they were and how talented they were, it occurred to me that I might want to become a lawyer. But when I did my own inventory, there was nothing about me that suggested that I could do what they did. There were no lawyer role models in my community. And I put that thought out of my head for a very long time. But with those young people, they stayed in folks' homes because they were unwelcome. They were outside agitators. And sometimes, if we're going to really make change, we have to go where we're not invited, and we have to do what is unexpected of us. They had to stay in homes because they were unwelcome. And also, they stayed in homes because at that time in Olive Branch, Mississippi, there were no hotels. And so in private homes were the only places they could stay. We do have hotels now, so if you want to come to Olive Branch, you don't have to worry about trying to find a place to stay. But that experience early on taught me that lawyers really can make change. But sometimes it means that they have to go beyond their comfort zone and do things perhaps that do not enrich them. But I think that when we think about it, all of us, as they say, have been able to drink water from wells that we didn't dig, to take shelter in buildings that we didn't construct, and to walk through doors that we didn't open. And we have to do that same thing for others. In talking about, thank you, in talking about public service and criminal justice, being involved in this section has been one of the great joys of my life because it's given me an opportunity to be on the fringes of some great work. And we know that our criminal justice system still needs work. 15 years after Justice Kennedy's address, I want to share with you again that almost 60 years ago, an organization known as the National Conference of Christians and Jews did a study on people's satisfaction on outcomes in civil and criminal courts. They surveyed people to have a sense of whether or not they believed they could go into court and get a fair outcome. And what they found almost 60 years ago was that by an overwhelming majority, African Americans believed that they could not get a fair outcome either in civil courts or criminal courts. That was followed closely by Latinos. Asian Americans had a higher degree of confidence that they could get a fair outcome, but the study used the term Caucasians had the highest belief that they could get a fair outcome, whether they were in civil or criminal court. And you say, well, that was a long time ago and probably things have changed. The Rand Corporation replicated that study within the last decade, and not much had changed. And when people believe that they cannot get a fair outcome in court, that is an indictment against each and every one of us. And all of us are responsible for doing what we can to change the environment in which we live. Now, you might say, well, that is an unreasonable belief by people. Well, Lucian mentioned that I became a judge in 1982, becoming the first African-American woman to serve as a judge in the history of Tennessee. Thank you, Madam. When I was sworn in on September 1, I had a wonderful investiture ceremony that morning in the courtroom. That afternoon, I had a docket. The man who staffed my courtroom was a friend. He was a middle-aged white male, Jim, Mr. Goldsby. He's now deceased, so I can say his name. And he was invested in me. He wanted me to succeed. And so when I took the bench in my elevated position that afternoon, I had only 4 cases on my docket, 4 traffic cases. But My point is about how my courtroom looked. I had 2-minute clerks seated just below me. Cynthia, I had an African-American female to my left and an African-American male to my right. At a 45-degree angle, I had a prosecutor, an African-American male. And ringing the courtroom, I had 4 deputies in Shelby County Sheriff's Deputy uniforms with a standard issue Smith & Wesson strapped to their sides. 1 African-American woman and 3 African-American men. The first person to come into the courtroom that afternoon was a young white male. He walked in, he looked around the courtroom, his eyes grew as wide as half-dollar bills as he saw no one in the courtroom who looked like him. He came to the bench with fear and trepidation and asked me for a continuance, and I granted it for 30 days. 30 days later, he came back to court with an African-American defense attorney. That may have been the person he was going to hire all along. I don't know. But Judge Jackson, I reasoned that that person felt probably like there was no way he could get justice in that courtroom because there was no one there who looked like him. And so I went to Mr. Goldsmith and said, I really appreciate your concern for me. I appreciate you wanting me to be comfortable, but we need to make some changes. We need to bring in a little bit of diversity. And so we did. I tell you that, sir, because it's not just African Americans who are concerned about the ability to get justice. Every citizen, regardless of race, gender, religion, or socioeconomic condition, ought to believe that they can walk into a courtroom anywhere in this country and know that their case will be decided on the merits and not on any other attribute. That is one of the reasons that I do the work I do now for implicit bias. I'm going to tell you one other quick story, but not right now. So we know that there's change occurring. We know about the First Step Act that's supposed to help us. It recognizes finally that the length of the sentence is not the real deterrent. It is the encouragement, the education, the opportunity that's provided for people to become productive citizens once they're back in the community. We know that there's a lot of work that needs to be done on bail reform. I hope that it affects each of us every time we read a story about someone who is languishing in jail because they cannot make a $100, $200, $300 bond. We just heard the story of the woman in Texas, 61 years old, in jail for criminal trespass, who could not make a $300 bond over a 6-month period and eventually died of cardiovascular complications. We have got to relook at how we're using the tools that are a part of the criminal justice system. And I know that Lucian is already in the criminal justice section is working on resolutions to urge the elimination of money bail. And that's not going to be easy. But many of you who don't live and work in those areas, lend your hands to the work of the section so that we can try and achieve some of these very worthy objectives. And then there is the Implicit Bias Initiative. And why am I so passionate about that work? I mentioned to you that every citizen ought to believe that they can get a fair shake in their race, their socioeconomic conditions, their class, their religion has no impact on the quality of their justice. But statistics tell us otherwise. Statistics tell us that even though we may profess to be fair and impartial, even though we may profess not to see gender or disabilities or class, our actions tell us otherwise. And I know that when you start talking about bias, people automatically hear race or racism or sexism or ageism, but that's not it. Implicit bias is unconscious. We're sometimes unaware even that it's going on in our heads. Those things, racism, that has to be a conscious act or an intentional thing at the surface. But implicit bias is just the opposite. It is unconscious. And how does it manifest itself? In so many ways. The statistics tell us and the science tells us that where we have the greatest discretion there's the opportunity for the greatest bias. And all of us, regardless of our race, have it. Regardless of our occupation, we are infested with that implicit bias. On the screen up there, you'll see the cover of the book that was produced by the Criminal Justice section. And Cynthia Orr, past chair of the section, is one of the contributing authors to that book. And we look at a whole range of biases. And we do work on this area all around the country because it's important. We cannot ever get to justice until we get beyond the barrier of bias. Let me give you an example of how it was manifest in a trial over which I presided. And I want to tell you, I don't know how my other federal judge colleagues deal with voir dire, but I want to tell you that judges and juries come out of that same pool and are infested with the same types of biases. And self-reporting doesn't really tell you much of anything. In this particular case, I was presiding over a drug trial, and I had done my preliminary voir dire. The fine prosecutor did his, and then the defense attorney came up to do hers. And she looked at the venire and said, "How many of you know what a drug dealer looks like? Raise your hand." And all of these hands went up, and she stopped. And in that silence, you could see people's hands slowly come down as they realized what they were saying by their actions. They said to her, "I know what a drug dealer looks like." And seated over at the table was a young African-American man who looked like he had stepped right out of central casting for the role of drug dealer. Now, how do you give someone the presumption of innocence? How do you assure their right to a fair trial if the fact finder says, "I know what one looks like, and by the way, looks just like you"? We've got to make certain that the people who are making these decisions are aware of the phenomenon of implicit bias or social cognition or unconscious bias, and that does not invade the judicial process. I know that in the news lately we heard a lot about reentry. All of us now know the name of Alice Johnson, who had her sentence commuted, and we have celebrated that because it spoke to redemption. And that was one case. Kim Kardashian did great work there. But you know what? Long before Kim Kardashian was busy trying to get someone released, the criminal justice section under the leadership of Jim Feldman worked with other entities and lawyers all around the country to go through some 40,000 applications and petitions and help people who were deserving of commutations get those commutations. And many of those people, almost, I believe, 3,000, have been reunited with their family. And you might say in the grand scheme of things, that's not a lot. But the effort that was put forward, the energy, the resources that this section dedicated to that work is enormous. And the number of hours that lawyers like Jim and others like you put into that is just amazing. We have got to continue to, where we can, step in and do those good works. I want to mention one other thing quickly, and that is felony disenfranchisement. Right now, there are 5.3 million people around the United States who cannot vote because they have been convicted of a felony. Many of them have served their time, but still they cannot vote. And that is another issue that all of us must be concerned about. In our state, if that condition still exists, then we ought to be concerned about that. I know that Florida has recently passed legislation. Tennessee's got something in the hopper. If there's nothing going on in your state, you need to look at that. Because are we a nation that says we want to judge people forever by the worst mistake they've ever made? And once they've paid their price, do we still want to say you can never again be a full citizen in these United States? I don't think that's what we want to do. Is it time for us to look at restorative justice in various communities? I think so, but I can't do that. You individually can't do that, but we can through organizations like the American Bar Association's Criminal Justice Section. We can put those things at the forefront. We can, in fact, recognize the role that mental illness plays in our criminal justice system. I know that Elizabeth Kelly is in the audience somewhere. She is a person who is passionate about that work, but I want to tell you a story about unintended consequences and mental illness. And then I'm going to take my seat after one other statement. When I was on the trial court, there came before me a man who was charged with a very serious crime. He was charged with being a felon in possession of ammunition. He was a person who had been diagnosed as being paranoid schizophrenic, and he was also bipolar. He was on medication, but living in the community, he, as so many people do, got off of his medication. And he went on a multi-day liquor crack holiday. While he was out living on the streets, smoking crack and drinking liquor, and picking up things and doing whatever he did, his condition began to deteriorate. And fortunately, he had the presence of mind at some point to realize that he was nearing crises. He called the police helpline, identified himself, and said, "Help. Can you please come and get me and take me to the hospital? I'm afraid if you don't, I could end up hurting someone." Good police officers, they said, "Where are you? Give me a description. We'll be right there to get you." And they did. They came, and he was there ready and waiting. Had a bag of things he'd picked up on the street. He had been engaging in activities over the time of his vacation, and he was freely talking about some of those things. As good police officers, before they put him into their squad car, before they took him to the hospital, they said, we got to first check that bag to make sure there's nothing in there to hurt you, us, or the people in the hospital. And they took the bag and did an intake on the hood of their squad car. They dumped the contents. And in that bag, there was one .45 caliber bullet. They took him to the hospital. He was admitted. They checked his background. He was a felon. They took the bullet first to the state prosecutors and then to the federal prosecutors. The federal prosecutors accepted it. And they obtained an indictment. And about 10 months later, when he was adjusted and back home with his family, there was a knock on the door. And the warrant was served. He was taken into custody. Because of his record, he was detained. And at some point, the prosecutors offered him a 15-year deal. He said, "That's a long time. Can't take it." His lawyer said, "Okay, we'll go to trial." And they went to trial. Only 3 elements to prove in a 922G case: possession, felony record, interstate commerce nexus. Good prosecutors were able to secure a conviction because he had the bullet. Mandatory minimum said 15 years. Mr. Basir was sentenced, and I will tell you, I thought under the circumstances of that case, notwithstanding the mandatory minimum statute, that the sentence was cruel and unusual, and that it lacked proportionality. I knew that if I adhered to that mandatory minimum, there'd be no consequences, but I wanted to push that up because I don't think that that's what Congress intended. I don't think that's the kind of case they intended that law to be used for. And so I sentenced for less than 15 years, long sentence, but less than that, because I wanted it to go up. And before that case could ever get to the appellate court, before the light of justice could ever be shown on that, Mr. Basir died in jail. That turned out to be a life sentence in response to a cry for help when the felon possessed a bullet. I have no criticism of the prosecutors. I have no criticism of the police, because all along the line, the jobs were done. But I do say to you that we have to help the lawmakers, the lawgivers, see that sometimes there are seen and unseen consequences, known and unknown, and I think we've got to do a better job of recognizing, as lawmakers, that sometimes these don't serve the purpose for which they were intended. I want to tell you today, there is a lot of room for work in the community, and we cannot continue to persist in the model that we apply today. I know that you are white-collar crime lawyers, but I want you every once in a while to go down to some of those courts of the people and bring your expertise to bear for someone who can't afford a lawyer, for someone who doesn't have a voice. I don't want you to go and pay their bail, but I do want you to go and see what's going on in some of those other courts where your clients don't necessarily sit. Dr. Kerry Ressler, who did a lot of work at Emory University in Atlanta, he did studies on certain communities. And what he found was, and we have a lot of these communities around the country, he found that people who live day in, day out in high density, high violent, high poverty communities have higher levels of PTSD in many instances than people on the front lines of war zones. There are policies being formulated right today that do not take those things into account. But you have the voice, the expertise, the access to work with policymakers to change some of that. Some of those things that they are formulating, people like Sandy's wife, Rosemary, working tirelessly, but they're working on the back end. You have the ability to impact that on the front end. And I think that you need to provide voice in situations and for people who otherwise have no voice. I know that I have gone over my 20 minutes, but I want to just share with you one final thing. All of us have a story. All of us are writing that story each and every day that we live and work. We determine what our story is going to be because we have control, in large measure, of that destiny. But we can alter the stories of some people, and where we can, that thing that we can do, I believe we must do, and none of us can do everything, but every one of us can do something. And how you use that time can really make a difference in that story. I want to leave you with a petite poem. And this is the last story I'm going to tell you before I take my seat, because this is going to show you how bold I am. In junior high school, when I was at the all-black school, we used to have a talent program. And this is going to feed a stereotype, but we had really talented students at our school. They could sing, they could play instruments, they could do all kinds of things. And I had the ability to do none of that. When I did my own talent inventory, I was utterly bankrupt. Couldn't sing, couldn't dance, couldn't play an instrument, couldn't do any of that. But I went to every talent program and I sat there thinking how wonderful it would be to be up on the talent program. But alas, I had no talent. One day, an idea came to me. I loved to read poetry, and I decided I would go and present myself and ask to be on the talent program to recite a poem. The talent coordinator, with gentle persuasion, at first tried to dissuade me, but I was persistent even then. And I pressed her until finally she relented and put my name on the talent program. And on that Wednesday, for that particular program, I was placed in the middle on the roster. And I was behind the curtain waiting. And you know how, you're just kind of all pumped up because you're finally going to get that opportunity. That's the way I was. There was somebody out there and they were really good. And then it came my turn. And I walked out to the stage, took the microphone, looked at the crowd, and began to recite the poem. Two roads diverged in a yellow wood. Sorry I could not travel both, but be one traveler long I stood and looked down one as far as I could to where it bent in the undergrowth. And about that time, a noise began to fill the auditorium. And it rose, and it finally got to a crescendo. People were not excited nor applauding. They were yelling, hissing, and booing and saying, "Get off the stage. We don't want to hear that poem." In that moment, I realized people were inviting me to leave the stage. And I decided that I would decline their invitation. And I remained. But that taught me a lesson. It confirmed for me that I had no talent. And so I never again went on another talent program. So today, I'm not going to be long with this poem, but I just want to leave this with you, because I have encouraged you to take action where you can. So this is the poem. It goes something like this. Ray. Lost yesterday, someplace between sunrise and sunset. 2 golden hours, each set with 60 diamond-studded minutes. No reward is offered, for they are gone forever. The time is now. We will never again see this time. Use it wisely. Thank you.